Hello everyone. My name's Michael Thompson. I'm President of the University of Sydney branch of the National Tertiary Education Union, the union for people who work at universities. Tonight's our occasional lecture. I'd like to thank everybody for turning up. I'd like to start tonight by acknowledging that we're meeting on the land of the Cadigal people of the Aurora Nation and pay our respects to their elders past and present. Tonight we're holding this because the NTEU has got its own groups at each of the campuses. NTEU for Refugees, it's part of a broader group, Unions for Refugees. Unions for Refugees got together last year, just after the Manus Island, when a number of us who are heavily involved in unions were pretty angry at the setting up of Manus Island, the Labor Party's way of dealing with refugees, the fact that they want to demonise refugees, the fact that they want to use the racism associated with some of the responses around refugees to take people away from the real issues. Anne-Marie is going to speak for about 45 minutes. We'll then have time for questions. Anne-Marie is a historian on immigration. Anne-Marie is based in Canberra.
Well, thank you very much for all coming today. Since 1901, Australia has successfully resettled over 800,000 refugees from many countries and has greatly benefited by their contributions to our nation. This is a history we have every right to be proud of. However, the increasing focus of both major political parties over the past 20 years on deterring asylum seekers from arriving by boat has tended to obscure Australia's continuing role in helping to resettle some of the world's 15.4 million refugees. I hope this evening I can help you appreciate Australia's important contribution to international efforts to resettle those fleeing persecution by explaining how our current approach to refugee intake and settlement is both similar to and differs from that of past Australian governments. Now, perhaps I should first explain why I came to write my most recent book, Hope, Refugees and Their Supporters in Australia Since 1947. In the early 1990s, when I was working in the Department of Immigration, I was offered a research fellowship at the ANU's Urban Research Unit. I subsequently published 2 books on the Department of Immigration's role in the evolution of Australia's migrant and refugee settlement policies from 1945 to 75. In 2001, like so many Australians, I was distressed by the Howard government's treatment of asylum seekers rescued at sea by the captain of the Tampa. I was also appalled by its decision to excise Australia's offshore territories from Australia's migration zone, where asylum seekers would be screened through a less fair process than that used on the mainland, and by its decision to send them to third countries, Papua New Guinea and Nauru, for processing. This was a radical departure from Australia's past treatment of refugees. I wondered how I, as a mere historian, could help my fellow Australians understand the circumstances that impel refugees to undertake a perilous boat journey to Australia, and the long history of support ordinary Australians have provided in helping newly arrived refugees integrate into their communities. I felt it was important to help refugees and their supporters tell their stories themselves, to have their voices heard. I'd been a contract interviewer in the National Library's Oral History program since 1999, and the library welcomed my suggestion that I add to their collection of refugee narratives. I was allowed to select my refugees, and I chose people whose stories reflected the main changes in our refugee intake and settlement policies since the Second World War. These stories were so moving and interesting that I decided to draw attention to them by incorporating them into a book that would engagingly and as simply as possible explain the true complexity of an issue that was becoming increasingly politicised and misleadingly oversimplified. Now, when and why did Australia first accept refugees? Before the Second World War, there was no special provision for persecuted people fleeing for their lives. Jews and others needing urgently to leave Nazi Germany from 1933 and later other countries invaded by Hitler's army had to make the migration requirements of the various countries they applied to for protection, such as having someone sponsor them. As in 1938, it could take over 2 years for some countries to process visa applications. Thousands subsequently died in concentration camps. In 1945, the gates of Auschwitz and other extermination camps were broken down by Allied soldiers who filmed the horrors that lay behind them. There was a widespread sense of guilt in countries like Australia that it had not responded in time to the urgent need for protection by persecuted minorities in Europe. More practical economic considerations, however, influenced the post-war Labour government's decision to accept refugees from the overcrowded camps in Europe. There was great optimism within Labour's wartime cabinet about the future of Australia following the war. It planned to free our economy from pre-war dependence on primary production through industrialisation, but this couldn't be done without a greatly increased workforce. After our first Minister for Immigration, Arthur Calwell, toured a number of refugee camps in Europe, he was not only moved by the refugees' suffering, he also saw a ready source of manpower. As most of the world's shipping had been destroyed, it was not possible to initiate a large-scale migration program, but the American government offered its remaining troop carriers to the International Refugee Organization to help clear the camps. Most of Calwell's newly formed department were ex-servicemen, many of whom had served in Europe, had witnessed the misery of the people displaced by war, and were eager to resettle them in Australia. He sent officers to the camps where, with the help of the International Refugee Organisation, they checked and interviewed refugees and arranged their transport to Australia. Australia had at that time the most generous refugee selection criteria of any other country. It would accept a refugee with their family without a sponsor, provided they were in reasonable health, not war criminals, were white, and prepared to work wherever they were directed for 2 years. The first boatload of refugees arrived in 1947. By 1953, the camps had been cleared and 170,700 refugees had come to Australia by this process. Others, like Peter Whitting, the first refugee who tells his story in my book Hope, arrived independently with the aid of international Jewish welfare organisations. This exercise demonstrates that through international cooperation, thousands of refugees with no other choice but resettlement can be given the opportunity to rebuild their lives and enrich the countries offering them protection. Now, what happened to these refugees after their arrival? Calwell was very aware of the risk he was taking by suddenly introducing such large numbers of culturally and linguistically diverse people into a country of about 7 million people, 90% of whom were Anglo-Celts and generally fearful of foreigners. The trade union movement in particular had a long tradition of opposition to the migration of foreign workers, fearing that they would imperil the hard-won rights and conditions of Australian workers. The Australian government addressed these fears by involving both the unions and employer organisations in the settlement planning process by co-opting them into the Immigration Advisory and Immigration Planning Councils. An agreement was reached that these refugee workers and the migrants who soon came after them would be entitled to the same wages and conditions as Australian workers. Knowing that his new, small and relatively unimportant Department of Immigration couldn't cope with the myriad settlement needs of newly arrived and often traumatised refugees, Calwell enlisted the aid of community organisations such as the churches, the YMCA and the Countrywomen's Association. In 1950, he created and funded the administrative costs of the Good Neighbour Council. Until its abolition in 1980, Good Neighbour Movement volunteers welcomed refugees and migrants into local communities Australia-wide. This organisation also served to educate the Australian public about the value of refugees and migrants to Australia by distributing government pro-migrant and refugee propaganda and screening Department of Information films depicting these newcomers in a positive way. To avoid creating an immigrant underclass, the government granted newly arrived refugees access to all relevant social welfare benefits. They were accommodated initially in each state in migrant reception and training centres. In these former military barracks, they were processed, given essential information about Australian society, and introduced to the government's extensive adult migrant English services. To help them with their personal problems, the Department of Immigration employed a team of professionally trained social workers in each of their centres. These newcomers, Corbell named New Australians, and they were allocated then to work or, in the case of women with dependent children, to holding centres. These centres were not flash, but were certainly not detention centres. As Hungarian refugee and later staff member at Bonagilla, Laszlo Mackay described in Hope, the living conditions experienced between 1950 and 1970 by the 330,000 new arrivals who passed through the Bonagilla camp in Victoria were reasonably comfortable. Refugees can settle best if they're given help during their early months to cope with the myriad challenges they face in an alien country. If they're given access to all government benefits they need, are helped to find work, and are welcomed by their neighbours, they will quickly become productive members of their local community and of the nation. Now look at Australia's efforts to become recognised as an international good citizen. Post-war Australian governments, both Labor and Liberal, were determined to be important players in international efforts to make the world a better place, by becoming involved in international organisations designed to promote world peace and human rights. From 1948 to 1949, former Minister for External Affairs, H.V. Evatt, served as the third President of the United Nations General Assembly and helped draft the Universal Declaration of Human Rights. Australia was also involved in drafting the 1951 United Nations Convention on Refugees and ratified it in 1954. The convention, for the first time, agreed on an official definition of a refugee. It defined them quite narrowly as someone who is outside their country and has, quote, a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, and can't be protected by his or her own country. This meant that refugees were not simply groups of people fleeing war or major catastrophes. They had to be able to demonstrate that they, as individuals, were under threat of persecution. This was, however, the time of the Cold War and the White Australia policy. To maintain the racial and political discrimination widely believed to be essential to preserving our national identity, Australian representatives at the convention supported a provision preventing the unauthorised entry of those seeking asylum. However, they did endorse various articles of the convention requiring Australia not to, quote, impose penalties on account of their illegal entry or presence on refugees who, coming directly from a territory where their life or freedom was threatened, and enter or are present in their territory without authorisation. It also agreed to give sympathetic consideration to those refugees who arrive in Australia without travel documents, if they had been unable to obtain them in their own country. While the 1958 Migration Act declared illegal those non-citizens arriving without a valid entry permit or visa, the treatment of asylum seekers was discretionary. and until 1989, the few who managed to arrive without visas and adequate identity documents were treated leniently. Now I'll move on to the formalisation of Australia's refugee policy and the establishment of a regular annual intake of refugees. There was no official refugee policy or regular annual intake of refugees by Australia until 1977. While the Refugee Convention does not require signatory countries to actively seek out refugees, before 1977 Australia had responded to the protection needs of those displaced by conflicts, such as those fleeing Hungary in 1956 or Czechoslovakia in 1968. Officers of the Department of Immigration were sent overseas to interview and process refugees with the aid of the United Nations High Commissioner for Refugees and the International Organization for Migration. Until the early 1970s, Australia's refugee intake was limited by the prevailing view of Australia's national identity as a racially homogeneous, culturally British and politically anti-communist society. Throughout the 1960s, these attitudes gradually weakened, both in the community and within the Department of Immigration, particularly under its secretary from 1961 to 1971, Peter Hayden. In conjunction with his minister, Hubert Opperman, Hayden orchestrated the gradual erosion of the White Australia policy. Mixed-race migration was introduced in 1964, and the migration for permanent settlement of skilled non-Europeans and their families in 1966. Whitlam's public abandonment of discrimination in immigration and redefinition of Australia as a multicultural society in 1973 was the culmination of this process. Party political considerations, however, delayed Australia's response to the protection needs of Indo-Chinese refugees until the change of government in 1975. In desperation, many took to boats. Over the subsequent decade, however, only 2,000 arrived in Australia that way. This was because in 1978 Australia became party to the ASEAN Orderly Departure Program that helped stem the irregular flight of refugees from Vietnam. In consultation with the Vietnamese government, a formal process was established through which refugees could leave Vietnam for a resettlement in other countries. In order to clear the overcrowded camps in countries of first asylum, an international conference was held in Geneva in 1989 that set up the Comprehensive Plan of Action. In 1996, when it was terminated, all the refugees in these camps with a genuine fear of persecution had been resettled, and those whose protection claims were determined to be unfounded had been returned to their country of origin. Until 1989, the fact that small numbers of refugees undertook the dangerous boat journey to Australia was generally regarded as evidence supporting their need for protection, and their numbers were not included in the annual refugee quota. Indo-Chinese arriving by boat before 1989 were not penalised or detained, but helped to resettle in the same way as authorised refugees, after being assessed as having a valid claim for protection. In his National Library interview with me, Department of Immigration Officer Brian Essay, who in 1979 was responsible for arranging the on-arrival accommodation for Indo-Chinese refugees in the old Darwin quarantine station, described his task as, quote, welcoming and processing the refugees, arranging medical checks, finding temporary hostel accommodation, and arranging their integration into communities in all states. His department's principal concern, he said, was to prevent them from forming little ghettos in Australia. The community support agencies that spontaneously arose in various places around Australia to welcome and provide much-needed services for these refugees was soon integrated into the Department of Immigration's Community Refugee Settlement Service. The government relied on these minimally funded community organisations to help refugees and asylum seekers settle until 1999, when it outsourced these services to major welfare organisations in each state and territory. In this way, it was able to restrict services only to those refugees who had entered Australia on valid visas. Now, when were mandatory detention and temporary protection visas introduced? In 1989, the Migration Act was amended to allow the detention of a second wave of boat arrivals, largely from Cambodia. The Keating government, with bipartisan support, opened the first of many detention centres on the mainland at Port Hedland in 1992. Although the legislation authorising mandatory detention of all unlawful non-citizens, first introduced in 1992, did not commence until 1994. For the first time, asylum seekers arriving by boat without visas were treated differently from those who arrived by air with one. The introduction by the Howard government of temporary protection, initially for refugees accepted from Kosovo in 1999, was another major change. Until then, all those accepted as refugees had been granted permanent protection. When their temporary protection visas terminated, some of the Kosovars, like our Albanian mother of 5 small children, Giseli Osmani, refused to be repatriated, believing it was still not safe to return. They were suddenly transported from the welcoming Bandiana safe haven to the Port Hedland Detention Centre in April 2000. In her interview, Giseli described her first impressions on her arrival. From the bus that took us to the detention centre, the country looked like a sandy desert. When we saw the notice saying Australian Correctional Management Detention Port Hedland, with its electrically operated doors and many people in blue shirts and dark blue trousers, I thought, is that a prison? Why are there so many police talking into small radios? It was a dead, sandy place where nothing grew. We saw many people in pyjamas run to the fence to look at us. Some women were wearing long scarves, and there were children in very old, bad clothes. I just felt shock. I didn't know it was going to be like that, with fences all round, so people couldn't get out. I thought, what have we done to be in a jail like this? We haven't committed any crime. As a child in Albania, Giseli had once been taken on a school excursion to a Second World War concentration camp. In Port Hedland's smelly laundry, which had only 3 washing machines for 900 detainees, only one of which was working, she found, quote, some Arab people playing cards while they waited for their washing to finish. I wondered how they could bear to be there. There were some old blankets on a chair that someone had washed, and I thought it looked just like a German concentration camp. I felt so depressed and thought, we are the unwanted people of the world. How has our current treatment of asylum seekers damaged Australia's human rights reputation? Our on-arrival services for refugees processed offshore with the aid of the UNHCR remain first class. The help given them is probably better than that provided to the earlier refugees. Before leaving UNHCR camps, they're given excellent pre-embarkation information to prepare them for their new lives in Australia. The teaching of English, particularly to children in schools, has become more professional and, most importantly, since 1989, refugees processed offshore have access to government-funded torture and trauma centres in all states and territories. Unfortunately, our progressively inhumane treatment of those who, unable to apply for visas, come by boat, has seriously damaged the image of Australia, so carefully constructed by earlier governments as a good international citizen. Various UN bodies have been outspoken critics of Australia's hardline immigration detention regime. The UNHCR has warned that the government's controversial policy of turning back the boats may be in breach of Australia's obligations under international law. In 2012, more than 3,000 fleeing persecution in Sri Lanka were given only a cursory form of screening, rather bizarrely described as enhanced screening, and over 1,000 were returned home. The UNHCR described this form of screening as unfair and unreliable. It's also concerned that the refugee processing procedures of the governments of Papua New Guinea and Nauru, where there are currently over 1,200 refugees, are neither fair nor efficient and may result in their being removed to a country where they face significant harm. Processing asylum seekers in third countries, it points out, does not mean that Australia can avoid its international human rights obligations, and Australia remains liable for the consequences of transferring them. While the Migration Act now requires all unlawful non-citizens to be detained, it fails to protect them against indefinite detention. Both the UNHCR and a parliamentary committee have found that mandatory and arbitrary detention is in breach of Australia's obligations under the United Nations Convention on Refugees. In 2013, the Australian Human Rights Commission described our current detention policies as one of the most restrictive immigration systems in the world because it is mandatory, not time limited, and people are not able to challenge the need for their detention in a court of law. The UNHCR found conditions on both Manus Island and Nauru harsh, below international standards, conducive to mental illness, self-harm and attempted suicides, and possibly in breach of a number of human rights, including the right to an adequate level of health care. Of the over 6,500 people in closed immigration detention in Australia in September 2013, almost 22% were children. Today there are over 900 children in detention centres, 170 of them on Nauru. Although the 1994 Convention on the Rights of the Child requires that a child should only be detained as a measure of last resort and for the shortest possible period, the Department of Immigration has revealed no information about the length of time refugee children have been detained. The Human Rights Commission has found that the mandatory detention of children as a first resort is fundamentally inconsistent with Australia's obligation under the Convention. Children are often detained in harsh physical environments, such as in the Leonora Centre in Western Australia. The Commission found that children on Christmas Island lacked recreational spaces and access to education, and that conditions there threatened their mental health. Most of the 358 unaccompanied children in detention are housed in prison-like conditions in Pontville, Tasmania. Between January and August last year, 50 of those children harmed themselves and 49 others threatened to. Their legal guardian, the Minister for Immigration, is also their jailer. Of the 52 refugees indefinitely denied protection visas because of adverse security assessments, 5 are young children. They're facing a life sentence despite not having been charged or convicted of any crime. The Human Rights Commission is currently conducting another national inquiry into children in immigration detention. Hope is a fragile virtue. It exists always under the shadow of fear of failure and despair. Refugees begin their search for protection with nothing but hope, and many have it destroyed in detention centres. Between 2011 and early 2013, there were 4,313 incidents of actual and attempted self-harm in Australian detention centres, and 12 deaths, half of which were suicides. The rates of mental illness in detention are high and continue to affect refugees once they are released into the community. The average cost of treating each of these damaged people on their release is conservatively estimated at $25,000 per person. Community detention is a much cheaper and more humane method of dealing with asylum seekers. By September 2013, there were over 21,000 asylum seekers in community detention, and the rate of absconding has been very low. In the United Kingdom and Europe, community-based alternatives to closed detention are the norm. However, the Australian government has managed to introduce punitive measures into community detention as well. The bridging visas given to those who arrived by boat after August 2013 allow them only basic accommodation assistance, limited financial support, and forbid them to work or even to volunteer. This may be a breach of Australia's obligations under the International Covenant on Economic, Social and Cultural Rights, especially if it forces them into poverty. Given that the government on the 6th of March 2014 capped the issue of permanent protection visas to refugees applying for protection on shore at 2,773 annually, such refugees could be living in the community for years without the right to work. This is happening at a time when the government is allowing employers to bring in unlimited numbers of foreign workers on temporary visas. To conclude, I will return to my introductory question: in what way is Australia's current approach to refugee intake and settlement both similar to and different from that of past Australian governments? First, what remains the same? In our commitment to resettle refugees referred to Australia by the UNHCR, we're continuing and building on the achievements of the past. It's important to recognise that resettlement in a secondary country is not a likely outcome for most refugees. In 2011, less than 0.8% of the world's then 10.4 million refugees were resettled. Over the next 10 years, from 2001, Australia has resettled 109,000 refugees, the largest number of any country on a per capita basis. Most authorised arrivals in 2012-13 were from Iraq and Afghanistan, countries where Australia has been militarily involved. According to research conducted by Monash University Scanlon Foundation, their acceptance was viewed positively by 3 out of 4 of Australians surveyed in opinion polls. Migration is still seen as economically and demographically vital to Australia's development in our current post-industrial age. Our largely skilled-based migration program, currently over 250,000 migrants a year, is introducing unprecedented numbers of workers. Foreign workers on temporary visas are replacing unskilled Australian labourers, and Australian skilled workers are losing their jobs as local industries close. In the past, successive post-war governments both calmed the fears and co-opted powerful community groups like the trade unions and employer organisations into helping it transform refugees and migrants into full and equal members of the Australian community as citizens. Our political leaders were determined to prevent the formation of a migrant underclass by granting them the same wages and conditions as Australian workers and making all newcomers eligible for relevant social welfare benefits. They were assisted in this endeavour by a much more powerful bureaucracy than we have today. From 1945 to 1971, only 2 permanent heads directed the Department of Immigration. Both Tasman Hayes and Peter Hayden worked skillfully with a succession of ministers and on important issues greatly influenced their decisions. Today, departmental secretaries are employed on contract, and uncertainty of tenure makes their staff compliant with the political interests of politicians. While we no longer discriminate against those seeking our protection on the grounds of either their race or their political views, we have created two distinct categories of refugees who are treated well or badly according to their mode of arrival. While Australia has a sovereign right to regulate entry into its territory, the military-led campaign dubbed Operation Sovereign Borders is clearly an overreaction to the attempts by relatively small numbers of unarmed civilians in leaky boats to have their claims for protection considered by Australia. At the same time, very little attention is given either to the majority of refugees who are processed offshore and arrive by plane on refugee or humanitarian visas, nor is much fuss made about those who arrive on temporary visas and subsequently make claims for protection, or the 50 to 60,000 who arrive each year and overstay their tourist or student visas. It's the minority of those who arrive by sea without visas who are demonised as illegals, despite their internationally recognised right to seek asylum and the fact that almost all of them, when processed, are found to have genuine claims for protection. The current outsourcing of the processing of asylum seekers in offshore Australian detention centres to foreign governments bears little resemblance to the procedure used in the 1970s and 80s to process Indo-Chinese refugees offshore. This issue has deeply divided Australians. Since the Tampa incident in 2001, approximately 25% of Australians have consistently supported the resettlement of irregular arrivals, although by 2013 this had declined to 18%. In January this year, when asked if the government was too soft on asylum seekers or taking the right approach, 22% of respondents thought it was too tough, while 60% believed it was either too soft or taking the right approach. Most Australians still mainly see refugees as migrants. The most common response when asked, "What do you think is the main reason asylum seekers try to reach Australia by boats?" was that they were coming for a better life. Only a minority believed that they were coming because they feared persecution, were in fear of their lives, or driven by desperation. The difference between those who are sympathetic to the plight of asylum seekers and those who want to send them back is principally one of values. The Scandon Foundation concluded that, quote, "The large measure of consistency of survey findings indicates that attitudes towards asylum seekers correlate with the values and outlook on life, not the tenor of media coverage. Values and outlook do not change in the short term." Since the emergence of Pauline Hanson and the One Nation Party in the mid-1990s, both major political parties have battled for the vote of swinging voters, those John Howard cleverly designated aspirational voters. While Hanson gained their vote by appealing to their resentment at the preferential treatment given to Indigenous Australians, Howard and his heirs have preferred to rekindle the embers of Australia's long-held fear of invasion from the north by targeting asylum seekers. It remains important for those seeking to contradict the bipartisan attack on boat people that they continue to educate the community about why they need protection, to humanise them by helping them to tell their stories and break through the barrier of silence and secrecy and censorship surrounding their mistreatment in detention. However, in the current climate, appealing to compassion has its limitations as a strategy for achieving change. At a time when Australians are losing their jobs and publicly funded services are being curtailed, perhaps a more effective tactic would be to get electors to focus on the unsustainable cost of the government's turn back the boats policy and of bribing third world countries like Nauru, Papua New Guinea and Cambodia to process and resettle our detainees. All Australians also should be encouraged to question the government's political motives for treating so inhumanely and publicly demonising such a